I view the liquor and lottery issues a little less stressful than some of the other issues we've been dealing with. So this is a little reprieve. Um, so let's just start out by having Tucker pull up the latest version of H313. I don't know. I asked him just a very short while ago if he could pull up the potential amendments that were floating out there into a strike all of the bill that came over from the House. And I think because we're familiar with most of this, I think he could probably walk us through rapidly, and then we can get some comments from other witnesses on it.
Tucker, did you send it to Nathan to post?
I don't think I'm not sure I even received it yet. So
Oh,
I just asked him to do it 15 minutes ago. So he was cutting and pasting. So yes, you can
okay.
send it to Nathan if you haven't,
So
Tucker,
that
and
people can see it.
Nathan can post it, and maybe you can pull it up on the screen.
Thank you. I sent it to Nathan, and I will pull it up right now for you all. So the strike all amendment affects two sections of the underlying bill. The first instance of amendment affects section 1, which deals with the fees for application renewal of alcoholic beverage licenses and permits. It adds a new subdivision 24 to subsection A to allow third-class licenses to be granted to the holder of a manufacturer or rectifier's license for $550. By way of a little bit of background, third-class licensees, the holder of a manufacturer or rectifier's license is permitted to acquire a third-class license to sell full pours of their products and the products of perhaps a limited number of other distilleries at a licensed location. But those manufacturers are required under current law to pay the full license fee, which you see up above in subdivision 6, of $1,095 in addition to the fees they pay to have their manufacturer's license. This subdivision 24 would cut that third class license fee effectively in half for a distiller.
So Tucker, is there a reason why we landed at 550 and not lower than that, given that they already hold the other license?
I ported this number over from another draft that I put together, and that was the number that was selected by the architect of that draft.
Mr. Chair.
So it's fairly arbitrary. There's no precedent. I mean, we're going to hear from the department on this as to the rationale as to this.
Because I'd like to see it lower. I'd like to see it at 250.
Okay.
Yeah, that's what has been floated by some of the advocates.
Okay.
And could you just remind us, Tucker, what the manufacturer and license or rectifier's license is? How much that costs? Because that's pretty hefty, as I recall.
Let's pull that up right now.
All right. I think it's good to look at it all.
Blocking me out from my search bar.
Oh. It's okay. We can look at this draft on, we now have this draft online, so we don't need to take up the screen.
The manufacturer's or rectifier's license is $285 for each license.
Oh, so it's not as high as the third class license. Okay.
So I'm going to need a little refresher course. A manufacturer's rectifier's license is a license just to be a distillery and produce spirits?
Or a vintner or a brewer, a manufacturer of alcoholic beverages.
Okay. And in this proposal, they're under existing law, they're being, if they want to do tastings at the distillery, they have to get a full third-class license, which is the equivalent of a bar license. Is that correct?
To do tastings, they do not need a full third-class license.
Okay.
And there's another license that's available, the fourth-class license, but the tension that currently exists is that the language there does not permit greater than, I believe, a quarter ounce of spirits to be added to each beverage that they serve at the licensed location. And perhaps the current practice is to serve more than that, and the distillers would like to continue serving what would be considered a full pour in this context, and will acquire third-class licenses to do so.
Right.
So, but so they're setting up a bar for a limited group of people at their distillery, and presently they have to pay the $250 or $295. What was it? $250 for the distiller's license,
They pay $285 for the distiller's
Okay.
license.
and $1,000 for the, and
Yeah.
they want to, they feel that's double charging in some ways, and they want to basically see that fee, the total fees they pay lowered. Correct? That's the issue here, and we have to determine if that's appropriate and to what amount.
Yes, and this is carrying from the work that you all did last session. The same issue with on-site service of full pours came up in the context of Vermont's wineries, and there was a club exemption built in for manufacturers and rectifiers under the first class license. And additionally, both the first and third class license requirements for manufacturers were amended to eliminate the requirement for adequate and sanitary kitchen space at their locations. So that's the context that we're working in now.
They could serve more modest amounts of food with what the full pours they were serving.
What did we do last year in terms of fee adjustments for you're saying for wineries?
I don't.
There was no fee adjustment for the first class license last year. So no fee adjustment for the wineries. It was just allowing the wineries to acquire a first class license under a club exemption, which was something that they had not been previously permitted to do.
Okay, so I'm confused. Are there wineries that presently pay a distiller's license or a winery rectifier's license and also pay for a bar license, third class license to serve tastings and more at their winery?
Yes. To clarify a little bit of that, the wineries pay for their manufacturer's license, and then they pay for the first class license, which is a bar that serves malt and vinous beverages.
Okay.
And the perhaps significant difference there is that the first class license is $230, as opposed to the third class license to serve spirits, which is $1,095.
Sorry,
So,
what's-
Mr. Chair, if I could, so looking at one of the small distillers in my area, distillery paid over 2,500 in permitting fees, and then on top of that was having to pay an additional $1,000 for this fee that we're talking about. It is completely, I feel like, out of whack with what others within this class of beverages, vinous beverages, are paying. I don't think it's fair.
Okay.
Yeah, and sorry, Tucker, what's the first class license cost again?
$230.
Wow, it really does.
And the first class license applies to vineyards, correct? And
First,
and
beer and
craft
wine.
breweries.
Yes.
And that allows them to, is that their manufacturer's fee or is that their server fee?
It's It's the on-premises service license. So it's for restaurants, bars, businesses of that nature that serve beer and wine. So the wineries are essentially opening a bar on
Right.
their premises under that first class license to serve wine.
Right. And their manufacturer rectifier's fee is for a winery is the same as it is for a distillery right now of $1,000 or something like that.
It's 285, I thought you said.
It's $285 across the board for any manufacturer.
Any manufacturer. So the difference is really between a winery and a brewery and a distillery is in the service permit. And one is up in the $1,000 range and the other one is in the 250 range. Okay, I was hoping to walk through the bill in total, but we've gone into this rabbit hole of this amendment. So we might as well continue to talk about the amendment. So can I ask Gary or Wendy what the justification, if any, is for charging 4 times as much for a distillery to serve their alcohol versus a winery or a brewery?
I am prepared to talk about what makes sense moving forward. Perhaps I don't know, and I think Commissioner Zahn, he can talk about what the justification is for charging significantly higher for that ability to pour full pours on site.
Thank you, Wendy. For the committee's edification, the different classifications of beverage alcohol have always been regulated and taxed differently. Beer, obviously on the low end of the ABV spectrum, has historically received lower taxes and fewer regulations. Moving up into wine with higher levels of alcohol, we have increased regulation, increased taxes, and that also applies to distilled spirits as we move up the line there. Higher ABV, higher levels of tax, higher level of regulation. So that's basically how the 3-tier system and the tax structure was instituted after the repeal of Prohibition. And for all intents and purposes, those applications still apply to the various categories. So to retail distilled spirits by the drink, historically, as we have just indicated, has a higher licensing fee versus a retailer of beer and wine, which has a lower fee. So that is basically the reason that these fees differ.
So if I know there is another rule of thumb that the fee charged should be commensurate with the amount of work that is needed to be done to oversee the process. You shouldn't be collecting more in fees than it costs the department to regulate that industry. So I would ask you, and I'm not playing devil's advocate, I just want to understand this. So I'd ask you, is there more to be done for the department in overseeing a distiller serving alcohol than a rectifier serving wine?
The answer to your question is no, there is no additional fee, but the assumption that there is a fee structure based on the amount of maintenance required for the account is incorrect. There is no correlation between the amount of time we spend working with the licensee and the type of product that they sell.
So it's totally based upon alcohol content.
That is correct.
If we do this, do we open the door on a precedent in a lot of other areas of fees and regulations that sort of turns back the clock on the principle that we should be treating less favorably the beverage that has more alcohol in it?
I would suggest that it's the committee's prerogative to establish a lower fee if you feel that it's justified. I am somewhat concerned that the other 850 Class 3 licensees will view a carve out and a discount to the manufacturing sector to be unfair. Obviously, this proposal will have to go through some money committee to be approved. I'm not certain that the House in conference committee would support this move. Our focus is obviously getting 313 across the finish line. And I am concerned that these amendments will be encumbrances and create additional burdens in accomplishing that goal.
Well, thank you for that. Could you explain further why the 800 other licensees would have any objection to this?
They have the same license. We don't have a specific third-class license per se for manufacturers. We have provided the manufacturing sector, Class 4 licensees, with some exemptions to the standard requirements for Class 3 licenses that apply to the other 800 holders. That includes certification for wastewater management, health department, certain local approval requirements, et cetera. So we've created a pretty significant carve out already in the Class 3 tier for the manufacturers. And we have not provided those same financial opportunities for holders of the same license that are not manufacturers. So I would suggest to the committee that we're creating a somewhat uneven playing field for the holders of the Class 3 license, which is over 800 of them in the state.
I think
May
I think I've lost you there.
May I add some context, Mr. Chair?
Yes, please, because I am lost with that.
Okay.
last comment. Yeah.
So this amendment is specific to the manufacturers that have a manufacturers of spirits in Vermont. Currently, there are 21 of those people, right? It's a small subset, very small. As opposed to, so Class 3 just means spirits, as opposed to Class 1, which is beer and wine, right? For on-premise. So when you look at all of what Patrick is talking about, the 800 or 850 other licensees of Class 3, those are bars and restaurants. They have a significantly more volume than a manufacturer, say Caledonia Spirits or Silo, that simply has a Class 3 license so that they can pour full cocktails. So the subset is quite small. And I am, looking through our licensing list, as Tucker said, it doesn't appear that the manufacturing fee for a manufacturer, whether you're a beer manufacturer or you're a wine manufacturer or you're a spirits, is the same. Correct? Isn't that what I just heard Tucker say?
I believe so. I thought I heard him say all manufacturers.
correct.
That's correct. So if it's the same fee to get a manufacturer's license, why would we charge a significantly higher fee for the same privilege of having that Class 3 license to pour your own product?
It's the same fee.
Well, the Class 3, what we're talking about, sure, the manufacturing fee is the same. This amendment is addressing the Class 3 license, and there is a disparity. Tucker says that right now it's $1,095 for a distilled spirits company to get that Class 3 license that allows them to pour a full pour of their own product, versus a brewery or a winery, you said was $230. So that's a huge disparity. When you're Mr. Chair, you were pointing out that the work involved is the same. So I'm not seeing why we would charge significantly higher for those 12 Vermont spirits companies to pour their own product than we would somebody else. That
21, Wendy.
Well, I so far, in terms of what I asked, I haven't heard a reasoning other than there's more alcohol in a spirit than there is in a beer and a wine. And I mean, I guess there may be some follow-up theory there, but that in and of itself doesn't cut it for me. But I was very interested in hearing the comment by the commissioner that the 850 other third-class licenses that pay 200 and I don't know the exact number.
They pay $1,000.
I thought they paid significantly less than the distillers.
Senator, the Class 3 license is specific to retailing distilled spirits. So the Class 3 license doesn't really apply to a brewer or a vintner. The Class 1 license applies to their particular operation based on the commodity that they produce. So we have two different lanes here. We have Class 1 that applies to brewers and vintners, and we have Class 3 that apply to, in this case, manufacturers or all retailers of distilled spirits by the drink. So all retailers of distilled spirits by the drink, whether you're a restaurant, a club, a resort, or a hotel, have to have a Class 3 license. It's the same license that we have provided to the manufacturers with certain carve-outs, but the price is the same. What we're discussing here is reducing the fees for the manufacturer tier, if I'm not mistaken.
So the reason why the other 800 people would be upset is they're continue to pay the $1,000 plus, but these particular ones that serve limited drinks, 21 distillers who serve limited drinks at their distillery, they would be reduced to 550 or 250, whatever we land on. And for some reason, you think that the full service bars and restaurants that serve beer, wine, and spirits would have some objection to that favorable treatment?
I believe that's correct, yes.
Mr. Chair, can we hear from the attorney? I see Tucker's face. I've been watching his face for the last few minutes. I feel like I'd like to hear from our attorney.
I think we got there with parsing this out, but the third class license applies to any establishment that is selling spirits from their licensed location for on-premises consumption. And that is the specific realm we're working in. You have a licensed location where you are serving alcohol for consumption at that location. The third class license applies to bars, restaurants, and in this case, manufacturers. And the issue that is being raised is that among the 800 and some odd licensees, you are carving out a small subset of the manufacturers and saying you may pay a lower license fee to serve spirits at your licensed location, but to the other licensees who are bars, restaurants, what have you, I think there's also provisions for rail cars and boats in there. They are going to be charged the $1,095 full license fee.
Thank you.
And to take that one step further, can you articulate their rationale or justification of why they should pay a lesser fee?
I don't think that is a good thing for me to do as your legislative counsel. You should hear from the advocates directly.
I'd be happy to share with you. As Deputy Commissioner Knight indicated, the manufacturers are suggesting, well, Class 3 allows them to retail liquor by the drink from their establishments. I think it would be logical to assume that they're going to have a much lower level of gross revenue business volume than a establishment that is in the business of food and beverage on an ongoing basis. So clearly the scale of revenue, the scale of business on the manufacturing level, for the most part, could be assumed to be considerably smaller, less revenue, less net, less resources to pay for licensing, I think is the general thought process here. I don't believe the department is adverse to the proposal. I'm simply pointing out some of the potential unintended consequences and potential pushback from other constituents.
Well, I hear some of the arguments that you just laid out. It would seem like there's less oversight. It's a small business operating at reduced hours, reduced volume. It seems like a much smaller operation in all regards, and a very different operation than running a bar and a restaurant. So, but so
Mr. Chair, may I just ask a question here? Patrick, I'm just curious that all your tiers are dictated, the price per tier is dictated by the alcohol by volume. Is there, does the department notice that there are increased liabilities attached with the higher alcohol by volume per license? I mean, are there more are there more enforcement challenges the higher the alcohol by volume? Why was that used as a metric for the increased cost? I'm just curious as we go forward.
Well, thank you for that question, Senator. I think it would be helpful to point out initially that the tax rates are established by the federal government. So excise taxes are a federal statutory issue. The fact that the DLC exists as a retailer and a regulator of distilled spirits, I think, is probably the most anecdotal answer to your question. We exist solely for the purpose of managing one tier directly, and that's distilled spirits. As you know, we do have interactions through licensing, compliance and enforcement, education, and other support features of the department to support both the beer and the wine manufacturing industry, as well as the global and national business models for those tiers. But the fact that we exist solely to manage distilled spirits, I think, would indicate that spirits are considered to be more problematic. They appear to require a higher level of focus and attention, regulation and management. So the answer to your question is historically the different tiers based on alcohol content have been managed to mitigate the negative outcomes. Spirit consumption historically has been associated with worse outcomes than consumption of beer, for instance. That's the way the laws are set up, and that's the underlying reason that they're different.
And
Okay.
and just may I just follow up with that? So
Yes.
do you, you have a whole enforcement division with which I'm currently very familiar, given that we're looking at the Agency of Public Safety and bringing them into that. Is there a heightened, are there metrics, is there data we could look at that shows that there is a more enforcement required of the distilled, with this higher alcohol by volume? I mean, I don't quite know how to ask the question, but is there more enforcement with manufacturers and rectifiers of distilled spirits and those who serve on premise?
I would answer that we do not have different approaches to the different tiers. We manage licensees generally that retail beer, wine, and spirits. Our focus is really the end result of consuming any or all of those particular products during a visit, if you will, to an off-premise establishment. So again, I'd like to emphasize that we do not have a different approach to working with manufacturers who hold third-class licenses than we do with a restaurant, bar, in a hotel. It's the same landscape for us, and we don't have a special approach to managing bars. Now, we probably pay more attention to bars or pouring establishments because people tend to frequent those establishments to imbibe. And I think the attention of the department is possibly a little bit more focused to working with licensees that have bar class 3 licenses. But that's really just a function of the outcomes being possibly a bit more problematic. Obviously, bars are open until late hours. People tend to hang out in bars until they close. And we don't really find the same type of thing in a restaurant.
Right.
Okay,
And just,
so to move on.
Mr. Chair, may I just clarify one point, though? There seems to be confusion, I think, because taxes are adjudicated and applied by alcohol content, not the fees. The fees are uniform. They're not based on alcohol content. The taxes are.
That's
the
correct.
excise tax, the excise tax.
Correct.
Which
But
is
not the fees.
Okay, so let me suggest a path forward here. We will take a 15-minute break in a few minutes, and I'd like the department people here to come back with some suggestions for a lower fee and defend them, and not just on political bases, but if there's any rationale that you can come up to defend. It sounds to me like there's a definite need to lower this fee. I'm unconvinced as to where it should go and what the reason is. Is there any precedent? Are we establishing any precedent that we will look back at and regret? So obviously that will ultimately be our decision, but I'd like to hear some choices and your best thinking on that, and we'll follow up and end this conversation. Then I'm not concerned about the bill going to other committees. We'll deal with that. That can happen very quickly. I don't think it has to go to the Ways and Means Committee in the House. It'll go back for them to concur with us. Ways and Means may weigh in, but we'll deal with that problem as it is. I don't think we should let the tail wag the dog here. If there's something we think is appropriate to do, we'll find a way politically to get it done. So let's move on, Tucker, if we can.
Mr. Chair, can I just say one thing, just because I'm just coming at this as a historian, and I just need to say, I feel like so much of the way that we deal with distillers and hard alcohol in this country is puritanical. I think that we view it very differently than we do beer and wine, and I just want us to be honest about that. Thank you.
Fair enough. So Tucker, can we keep walking through the bill, even though, let's go through the entire bill again. We have done it once, but we'll refresh our memory and make sure we're okay with all these other sections.
Absolutely. Would you like me to pull it up on the screen again, or would you like me to just walk through it? Okay.
No, pull it up, please.
So also within that section 1 is a new fee for standalone third-class licenses. These are third-class licenses that are applied for without any other added license. So for reference, bars and restaurants typically acquire a first and a third-class license to serve everything from malt beverages, vinous beverages, fortified wines to spirits. The standalone third-class license is an establishment that is selling only spirits. So that would, in this case, be the distiller that is applying for their third-class license. It is a local fee of $50. And
this is, the House put this in, right?
The House put this in.
So
that local.
So this is doesn't change the fee they pay to the state. This is a $50 add-on that goes to municipalities.
Right.
That is correct.
Yeah. And
what's the rationale for that?
From what I understand, over the last few years, and perhaps even in, I always say Act 13, but I believe it was just H13 with a different Act number, the issuance of these standalone third-class licenses and the administration of it was largely put on the municipalities as the issuing agent here.
Okay.
And I'm happy to help clarify that if Senator Sorokin, if you'd like. I mean,
Very quickly,
yeah, very briefly. So if they get a first and a third, the municipality gets a share. If they just get a third, there wasn't yes, if they just get a third, there wasn't a provision for the municipality to get anything. And typically no one got just a third without a first. And so the municipality does some processing and they don't get paid anything. This was a way for them, because I met with the municipalities several years ago about this, the town clerks and the League of Cities and Towns. And they just felt like they were doing this work for free and they shouldn't have to. And that was the request for the $50. So
this is like a straight up bar that serves only goldfish and stuff like that.
that serves only spirits. That's correct.
Okay.
And there's not a lot of them, by the way, but still, it's a possibility. So,
Right. And do we,
That may include the distilleries we've just talked about, right? That serve just their own product. Is that true or not?
I can't remember if there's a carve out there for them not needing the municipal approval. That was one of the things that happened in the past.
we
Okay.
should double check that. But I mean, this is fairly standard to have a municipal fee for the permitting of these, isn't it? For the municipalities, don't they, isn't there always a local licensing fee?
There is a share of first class license fees that goes to the municipalities, which is what Gary was just talking about.
Right.
There's a fee sharing provision in this same section.
So Tucker, does the distillery that does pours as samples and stuff at the distillery, are they going to have to pay this $50?
It was my understanding that yes, they would have to, but with what Gary just brought up, I will go back through the manufacturer statute and the third class statute and see if there's a carve out from local oversight and local administration for manufacturers.
Okay. Let's keep going down.
Section 2 is a section that establishes the sale of alcoholic beverages for off-premises consumption. This is the delivery and curbside pickup for each of the licensees. To bring you back, the first and third class licensees will be able to sell their alcoholic beverages with a food order for delivery or pickup, and provided that the container that they sell the alcoholic beverages in meets certain requirements, including a tamper evident seal and a label that lists the ingredients, states that it contains alcohol, and has a serving size written on it. Second class licensees will be permitted to provide curbside pickup of the unopened containers of the beverages that they sell. Same with fourth class license locations. Those are manufacturers that have the on-site sampling license. They will be capable of providing curbside pickup of unopened containers. And here in front of you, you see the requirements that I ran you through for the first and third class licensees for their containers.
And at the moment, how long is this extension? This is an extension of an emergency order, an executive order. And this is proposed for another 6 months. Is that right?
I wouldn't frame this as an extension of the current executive order. This is a 2-year program that the General Assembly is setting up that would allow these licensees to continue to act as they have under the emergency order, starting July 1st of this year until July 1st of 2023.
Okay. So I had sort of been okay with this as an extension of the emergency order. This will, to use the arguments everybody uses against anytime we put, a sunset in. If we do this for 2 years, this, the pandemic is, as we know it, is going to be, I hope, phased out over the next, we'll see radical changes, hopefully, in the next 6-8 months. To do this for 2 years to me is basically saying we're okay with this forever. And I'm not so okay with this section at more than to the emergency order. As long as it extends through the emergency order, I'm okay with this, but I'm
Senator Clarkson,
having trouble.
if this were only to extend through the emergency order, we wouldn't need this bill because the emergency order includes precisely these privileges right now.
Right.
So
Oh, we didn't have to
the
extend it.
the whole purpose of this is there's some question in terms of whether the executive order on carryout, the governor has the authority to continue this
Right.
once the emergency ends, and they want to continue this as an economic development tool and
Impact.
with impact. Right.
I would then be willing to look.
To wrap up this section, the Board of Liquor and Lottery is given rulemaking authority to adopt rules and forms necessary to implement this section.
Have to adopt rules. It's permissive. I mean, and that's, we should hear from the department on that, whether they absolutely need rules, because rules could take 6 months. And if we do go down to 1 year, there could be very much a hiatus. And then this whole pilot could only exist for 6 months because it takes so long to do rules. But we'll talk some more about that. Let's go forward.
The next section deals with festival permits. It clarifies the festival permit statute to state that a festival that is required to be permitted under the section is one where the primary purpose is the service of alcoholic beverages. It has some requirements for the permit holder. So in this subsection D, you have some of the more detailed requirements that you all debated and discussed in the past. The first is that attendees are required to pay a minimum of $5 as an entry fee. And then you have specific and enumerated service limitations depending on the alcoholic beverage. Malt beverages may be sampled in containers that contain not more than 12 ounces, and no more than 60 ounces can be served to any one person. Vinous beverages, that is limited to 5 ounce pours, 25 ounces in total to any person. Fortified wines, 3 ounces per pour, 15 ounces total. Spirits, 1 ounce per sample, 5 ounces total at any one event. And then subdivision E acts as a catch-all for festivals where multiple forms of alcoholic beverages are being sold. And the limitation there is 6 US standard drinks containing 3.6 fluid ounces or 84 grams of pure ethyl alcohol. And I believe I said this during the initial walkthrough, but I would highlight that subdivision, the catch-all, as one that will have a, if not a majority, then a plurality of these events that are happening, because cider and beer are often served together at these festivals, and they are malt beverages and vinous beverages and would be caught by this subdivision. Wrapping up this section, the festival permit holder is still required to comply with all of the other provisions of Title VII, including overlapping limitations on the service to intoxicated persons and all other requirements of their license.
Sorry.
There's
May I
nothing.
just ask a question here, Mr. Chair?
Go ahead.
So this raises the question, and maybe I'm just not seeing it because this isn't new language, that the liability piece, right? Person, because we hold the person who has overserved somebody who's then caught and is way over the limit. Who is liable at a festival?
That is going to be an interesting analysis of the dram shop laws, and then what I believe is known as the last location served law. And maybe someone from the department who works with enforcement could clarify who would be responsible for a person who is injured as a result of over service at a festival.
My question was going to be similar because I know we have fairly solid dram shop laws in the state of Vermont. I think the person serving could certainly be personally liable, as could their employer or whoever has the agency over that person. And I know our dram shop laws are pretty strong and have become effective over time. But my question to Tucker and to the department is, I just wanted some assurances that dram shop laws would apply. If anything, it's probably making them stricter because now we have specific volume, more specific or more stringent volumes that you can't supersede. And my understanding of dram shops, even if a person would look at the person you're serving and they appear intoxicated, you
Well, I'll defer to Commissioner Delaney.
It fully with this type of event. I hope that answers your question.
So it's the permit holder,
Yep.
right?
The event organizer, the permit holder.
And have we, I mean, we already have a bunch of these festivals. Have we had many issues that you were aware of so far?
Obviously, festivals are certainly part of the Vermont warm weather culture and remain popular. The issue here is that we've never had any parameters to apply to the events, to the permit holders. We've had a general sense of confusion, really, from the department's enforcement and compliance standpoint. The organizers have also been burdened with a lack of definition, so there's always been a certain level of uncertainty. There's also been a level of inconsistency in terms of how the events have been managed. And from a regulator standpoint, we're really in a much diminished position to provide services if we're not all working on the same page. So that's really the intent of this proposal. I would like to share with the committee that there's been a lot of collaboration with the industry to come to our original proposal. Obviously, we've decreased the amount of beer possible in the statute, but for all intents and purposes, this creates a level playing field that empowers us to be more helpful in working with event organizers and to basically create some consistent standards.
Thanks. That's helpful.
May I ask a clarifying question of the commissioner? If
Sure.
that's
Certainly.
permitted.
Of course you are.
So are you indicating that the festival permit holder and each of the licensees that has their tent where they're serving could be jointly liable for over serving a person at the event?
Well, Tucker, I would have to defer to a legal specialist, quite honestly. That is a good question. I would be inclined to suggest that there is a shared responsibility and liability. If I'm an event organizer and I get sued because one of the participants in the event have not fulfilled the expectations, and I've been sued by somebody through Dram Shop, it's likely that I would probably go back and look at the perpetrator, which is the individual participant, and seek some type of compensation. But I don't want to get too far ahead of the curve here. I'm not a lawyer, and I would defer that assessment to you.
Yeah, that's a interesting question because, yeah.
For the
It
committee's edification, the reason that I asked that question is that in the House, a representative asked in committee whether there would be per se liability if you serve more than the volume amounts that are set by statute. So who is responsible if a person consumes more than the 24 ounces of wine or whatever it was? Is it the person who serves the last drink? Is it the permit holder? And does this statute now set a per se statutory level of liability for overservice? And that was a novel question that in my research I could not answer for that committee, but that could be solved here if the answer is, well, regardless, there is joint liability for the permit holder and for the individual licensee who is serving.
You could do some research on the dram shop law, but I would be very surprised if all of those parties were not joint and severally liable, and it would be per se liability. There's no reason to put levels in there if they don't represent, if you can waiver from those levels. I mean, it could be potentially an affirmative defense that if you served 3 pours to a 300-pound person, that they say, well, I served him 3 pours and he clearly wasn't drunk, so I shouldn't be held liable for his ensuing auto accident. I doubt that's going to fly. But you can look at the dram shop law, but I'm pretty sure that that's what you'll find. And I think anytime we put levels, that is the definition of per se liability, unless you can come up with some mitigating factors that are somehow specifically allowed in that part of the statute. But anyhow, that's just one retired lawyer's opinion. So, but let's move on.
Well, and hard to trace as you go from booth to booth. I mean, I think that's
It's all part of the trial process.
Mhm.
The evidentiary process.
whoops.
Section 4 amends the statute relating to promotional tastings for licensees. The language being struck here would allow the staff of first or second class license locations, and in the following subdivision, third class license locations, to sample alcoholic beverages that are being offered for promotional tasting without having to be off duty for the rest of the day. So put more directly, staff that are working would be able to sample these alcoholic beverages while they are working.
Why?
Subdivision 3 eliminates the requirement that prior to these promotional tasting events, that there be 2 days notice given to the Division of Liquor Control. Section 5 is the sunset of the.
Sorry, may I just clarify? That was the restaurant request, which is right, that this was for them to taste wines that they're going to buy in bulk for their restaurant, that they had to do all this sort of getting permission to have sample the wines before they make big purchases. Is that what, am I remembering correctly?
Or if a manufacturer is having some promotional event with a restaurant and the servers are going to be serving wines, beers, whatever, that are going to be featured for the evening on the menu, they would be able to sample it and know what they are selling to their customers.
Right. Yeah, this is the piece, remember, committee, that we didn't have time to include last year, as I recall. Okay.
Section 5 is the sunset of the 2-year program for delivery and curbside pickup of alcoholic beverages. In Section 6, we have a temporary fee reduction for the renewal of first and third class licenses by clubs. It notwithstands the fee provisions related to first and third class licenses for clubs, and waives those fees for the year 2021.
What's a club?
A club is a fraternal organization that is operating under a federal charter, I believe is the most easy way to put the definition. It's in 7 VSA section 2. You can read through. It's exhaustingly long, but think of the American Legion or the Fraternity of Eagles or the Moose Lodge. Those are the clubs.
And as I remember, we had this conversation about country clubs. I mean, what people normally think of as clubs in the rest of the country aren't necessarily these. I mean, there are clubs too that are independent of fraternal, that aren't fraternal organizations.
What
They-
is what are the renewal fees? What do they amount to?
They are the fees that we talked about much earlier in the committee meeting, $230 for the first class license and $1,095 for the third class license.
And we're waiving these?
What was
That's
the
what this provision does.
what was the rationale that you heard in the House to waive these fees?
The discussion was around the impact of club closures during the emergency order. So unlike other establishments, clubs have effectively been closed for the entirety of the COVID response
So is this time limited?
for the year 2021.
Oh, so it's just for 1 year.
Right,
Yes.
so it's kind of acknowledging that they weren't allowed to operate and receive any revenues. And so they paid for a license that they couldn't really use. for
Right.
revenue.
Got it.
Have
Got
we-
it. Got it.
Has there been anything done regarding this in terms of other restaurants and bars?
Yeah, everybody did this. Everybody paid for a license they weren't able to use.
There were at least 2 bills in the House that contained this language. One was specific to clubs. The other provided a 50% waiver to all licensees, first and
But-
third class licensees in the state.
At least restaurants were open, even if they had much reduced capacity, they were open. And these fraternal clubs were completely closed down, as were most bars, right?
Okay,
Mr. Chair, may I offer just a context of the dollars collected for those?
yeah, I was
Yes,
gonna
that would
ask,
be-
I was gonna
Yeah,
ask if there's
so-
a fiscal note on this.
First class club license, which is the beer and wine, last year was $18,170, 79 renewed licenses. For third class club, there were 75 renewed licenses for 82,125. So we're talking less than $100,000 for a year.
Sorry, Wendy, what was the revenue on the third class?
Third class club was 82,125,000.
And the first one was the first class license was 18,100.
170. Those are for clubs.
And that's about a position. You're saying that the department can absorb that loss in revenues?
I didn't necessarily say that. I'm just putting it in perspective that it's not a significant amount of money when you look at the total amount of revenue that the department brings in for sales and services and licenses, which is, exceeds $84 million a year.
Okay,
I'm just adding context for you to
Right,
help.
no, I appreciate, that's appreciated, thanks.
let's finish up on sports betting and then we'll take a break and hopefully the department could answer the question I posed on what fee they would like to see reduced to or the justifications for various levels. And then I would like to hear from the department overall on each section, whether they have any problems with the bill. It seems, if we come up with a reduced fee and also this 100,000 we just talked about, this bill, clearly I think this bill has to go to finance under the rules anyhow. but I think we should probably ask for a fiscal note,
I would
Well,
agree.
whatever we come up with. And there may be some, I think there'll be financial impact to the revenues of the states on the carryout. Whether we do a year or 2 years, that's additional monies coming in to offset the additional loss of revenues from their closures, but there's got to be some projections on that as well.
I don't
So-
know if we collected that data specific to the to-go drinks and the revenue. I don't know.
I don't know how joint fiscal does its magic, but somehow they do it. Okay, let's go on to section 7, Tucker.
Section 7 will require the Office of Legislative Counsel and the Joint Fiscal Office to submit a written report to your committee and the House Committee on General Housing and Military Affairs on or before October 15th of this year concerning the current state of regulated sports betting market in the United States. In particular, the report is required to examine and analyze the sport betting laws in each state that has an active or proposed sports betting market, studies carried out by other states concerning the legalization, taxation, and regulation of sports betting, the models for regulation of online sports betting that are currently operating in other states, including a summary of the tax or revenue sharing structures that are used in each state. And then for each state with an active sports betting market, the state revenue that has resulted from that. Finally, any reports or information concerning impacts on problem gaming in the states with regulated sports betting markets. Computer's freezing up. Subsection B requires that while preparing the report, that Legislative Counsel and JFO will solicit input from the Department of Liquor and Lottery, the Department of Taxes, the Office of the Attorney General, and here at the end, other stakeholders. That is the one point here that I would highlight that might need some specificity so that Leg Counsel and JFO are not in the position of selecting who they're hearing from, which might look improper or project some appearance of partisanship. The effective dates are staggered here, except that the fee reduction for first and third class licenses for the clubs is going to take effect on passage so that the department can start moving forward with license issuance without those fees.
Do we have to do anything in terms of if we waive the fees on clubs for 2021 to make it retroactive so that they don't have to pay any interest and penalties?
That's a good question. And now that it's staggered license renewals, is it good for their whole year of their staggered license? I mean, what if their license renewed in October of 21? I mean, would it be good, obviously, for that whole year?
It is my understanding, to answer Senator Sirotkin's question, that there is no need for the retrospective accounting for licenses that have been renewed, interest, penalties, fees, whatever it may be, because the department has been working with the license holders and has not required renewal up to this point in the year. So they have deferred the renewal requirement. See the commissioner.
Tucker,
there.
may I please interject? The department 2 weeks ago started issuing licenses. We didn't have the luxury of awaiting a decision from the legislature. We had thousands of licenses piling up. We were compelled to start moving those through the system so that the licensees were not impacted by the conversation. Whatever that we come up with in terms of reduced fees to a significant degree will require a reimbursement for those that have already paid their fees and have been issued their licenses in line with our standard annual licensing cycle, where we license about 8,000 people.
Do you think well, in terms of this club exemption, do you think you need any further clarity to make sure that you send them back their money?
No, there's only 95 of those licenses. And so that's, again, a relatively small subset. And that would be considerably less burdensome than
Right.
reimbursing thousands of them, but we'll do what we need to do.
I'm a little confused when you say reimbursing thousands, other than the distilleries that we're talking about getting a recommendation from you in the next 15 minutes.
Mhm.
Where else have you put out bills that overcharge people if this law went into effect?
Thank you for that question. The drop dead date for licensing submittals is the 30th of April.
Right.
And as I indicated, due to the buildup of pending licenses and the time frame, we were forced to start issuing licenses and accept full payment for those licenses. If the committee and the legislature decides to cut the licensing fee in half as proposed, then the department will be compelled to reimburse those that we've received full payment from, to reimburse them for the amount of the discount.
I understand the theory.
No, that's a reality, Senator.
No, I'm misunderstanding something then. The
Okay.
practicality is, I thought that this reducing the fee in half or whatever number we come to is going to affect 21 distilleries.
We're talking about reducing the third-class licensing fee by 50% for all third-class license holders.
We are?
I thought we
That-
were doing it for the 21 distilleries.
I'm looking at the bill and I'm interpreting the language to include all and not just a subset of manufacturers with third-class licenses. Am
Ah.
I incorrect, Tucker?
So, Tucker, can you weigh in here?
Sure. Commissioner, are you looking at section 1? That subdivision 24 states expressly for a third-class license granted to the holder of a manufacturer or rectifier's license. That would be strictly the distillers.
Thank you for that clarification. There was a proposal, as you alluded to earlier, Tucker, to grant relief to all third-class license holders. I apologize if I crossed over into that lane and confused the issue. We're obviously talking about waiving fees for a subset of first and third class licensees referred to as clubs. And those fees, there's 95 of those licenses. We can live without that revenue. We can live without the revenue from the fourth class license holders, but the larger universe of thousands of third class license holders, that's basically where I got sidetracked there.
Okay,
My apologies.
thank you.
So-
Okay, so we don't need to change the language. They'll figure it out. It's small enough.
Right.
I
Something,
see Steve Klein here, and let me, because I know his time is crazy like the rest of us at this time of year, so I don't want to spend very much time. Steve, have you seen the language on a sports betting study? And if we're going to do something like that, we definitely need help from joint fiscal in terms of projecting numbers on revenues and stuff like that. Do you have any problem? I know we could just simply ask you to do that, but I thought it'd be appropriate to include you in the language along with legislative counsel. You recall last year, the Senate voted 29-1 to actually do a summer study task force, which called for the cooperation of the Joint Fiscal Office as well. So I just want to get you on the record that you can help out here.
Yeah, thank you very much, Steve Klein from Joint Fiscal. I see no problem with the study. I thought it was very appropriate. And the only thing I would just one concern is I'm not sure I totally agree with Tucker on the notion. I actually like the general ability to talk to interested parties, because this is a very evolving field right now, and the people that are involved and the people we need to talk to change all the time. And I think we just need flexibility as we approach this. So I wouldn't want to take away from that language that you put in that really allows us to think through what makes sense. And you can judge the study any way you want when we're done. But
right.
I thought you handled that pretty well. I just want to say it's also every state's, because of their agreements with sports betting and the nature of the sports are going to differ. The revenues are not going to be, it's not an easy prediction, but it's no question this makes a lot of sense.
Thank you. And as far as the comment you made, I agree with you. And Tucker, if you're concerned about it, we can rephrase it to say that, that you should consult with other people who express an interest in being heard, or and other relevant stakeholders that the authors identify. That's all, that are relevant. It's pretty generalized language. I understand your concern, but I think we can get by that.
Yeah.
Thank you, Steve. That's
Okay, no problem. Thank you.
bye-bye.
Bye.
Okay, Senator Clarkson, do you have a question? Yes. go
Yeah,
ahead,
I just had a question because Patrick used the word thousands. And I thought I heard that there were only, one of you, I think Wendy said there were only thank you, sweetie, that there were only 800 third-class licensees. Am I wrong?
I apologize. I was confusing a previous proposal to include all third-class licensees, Senator Clarkson.
Right, no,
That was a mistake on my part.
how many third-class licensees are there? I thought there were 800.
There are 487 plus 124. So there's basically five. Yeah, I mean, adding it up, it's between 700 and 800, it looks like.
Okay, so
That's
there are
correct.
roughly 800
Yeah.
licensees,
Yeah.
third-class licenses. That's all. When you said thousands, I thought, oh, maybe I just misheard. Okay, great.
Okay. Well, thank you, everybody, for your patience. It's now 9:47. Why don't we come back at 5 after 10? And Wendy, do you understand what the request is of the department? Do you folks
I do.
understand? Okay.
Yes.
So why don't you huddle with Gary and the commissioner and give us your report back as to where you think that number should lie. I think what I heard of the number in the bill, it was fairly arbitrary. It came from the desk of, I don't know where it came from, but so if we can find a number that we can defend from some, and I'm also concerned that it not set a precedent for other things. If I want there to be some justification for the number, I think there is a lot. It's a much smaller establishment for sure compared to the average person we license. So I think the number should be less. Okay. Thank you. We'll be back at 5 after 10.